Again, I will be very brief. I'm going to allow Abby Williams of the Hague Institute for Global Justice to introduce our speakers. But before we start, I want to thank the government of the Kingdom of the Netherlands for its support for this event and for bringing these distinguished judges to us. I should tell you, many of you were at the Willig Luncheon yesterday, which was really an extraordinary event. And so we have the chance, we have actually a double dose. We have had the chance to honor Judges Shui and Donoghue and Sebutinde. Now we have a chance for a substantive discussion with them. So again, Abby, thank you for hosting this, and thanks to the Dutch government for supporting it.
Well, thank you very much, ladies and gentlemen. A very warm welcome to what I'm sure will be one of the highlights of this year's ASIL meeting, a conversation with three judges of the International Court of Justice, Judge Joan Donoghue, Judge Sebutinde, and Judge Shui. As president of the Hague Institute for Global Justice, it is a tremendous pleasure for me to share the stage with three of my most eminent colleagues from The Hague. I very much look forward to what I'm sure will be a wide-ranging discussion, engaging many of the issues that the court is facing today, as well as the effectiveness of international law more broadly. I also look forward to discussing issues of diversity as pertain to the role and work of the court. But gender is only one aspect of diversity, which I hope we will discuss today, because perhaps more relevant would be the judges' approach to their work, the diverse perspectives and backgrounds which they bring to the bench, whether in terms of the legal systems in which they were trained, or the different paths in their careers which they charted before coming to the court. So I think it is now my distinct honor to introduce today's panelists, whose views on these issues we're all very eager to hear. Judge Donoghue was elected to the court in 2010, prior to which she served as principal deputy legal advisor to the U.S. State Department. She has also had a distinguished career as a professor at Georgetown University and George Washington Universities. Judge Shui was also elected to the court in 2010, prior to which she served in senior legal and diplomatic posts in China's Ministry of Foreign Affairs. These posts included Director General of the Department of Treaty Law, China's ambassador to ASEAN, and China's ambassador to the Netherlands. Judge Sebutinde was, prior to joining the ICJ in 2011, a judge at the Special Court of Sierra Leone. She joined that special court following an impressive career in Uganda, where she began her career in the Ministry of Justice and ultimately served as a High Court judge. The format for this afternoon's discussion is as follows. I will begin by posing initial questions to the judges designed to frame the discussion and highlight some of the critical issues that the ICJ is currently facing. And then I will provide an early opportunity for the members of the audience, to engage in the discussion. I will take the questions in groups of three to maximize the discussion. It is striking, I think, that even among the legal community, general knowledge of the ICJ's work seems not always to be as developed as it might be, particularly as controversies surrounding the International Criminal Court take up much of the oxygen in the debate on international law. So the judges and I therefore thought it opportune to begin today's sessions by speaking first in general terms about the ICJ's role and function. So let me start by asking Judge Donoghue whether you could remind us briefly of the key features of the ICJ For example, how the judges achieve those in it, so perhaps the audience may understand how it functions. Judge Donoghue?
Thanks. I'm happy to do that. And thank you to all of you for being here. I often think of myself as an international law nerd, which I'm pretty happy to attribute to myself. And you all deserve the same label for being here this afternoon instead of enjoying this incredibly nice weather outside. The Hague and the American Society of International Law has something in common. The Hague is a national capital, but it is also an international center for peace and justice. And for us, that's where the Peace Palace is located, where we work. And in the same way, the American Society is a national society, but its membership includes 40% of members who are not American. So it's nice and fitting, I think, that we travel with Dutch sponsorship here to talk about our institution in this setting. And I should also say that there are experts in this audience, at least one former judge of the International Court, Judge Schwebel, is here, people who've appeared as counsel before our court. But we really wanted to make sure that those of you who don't have that expertise could participate in this conversation. So with that, our court is the principal judicial organ of the United Nations. We are 15 judges from around the world, representative of the regions of the world, and elected by the Security Council and the General Assembly. We hear two kinds of cases. We hear cases in which another organ of the UN asks for an advisory opinion, but the bulk of our work, about 80% of our work, is in what we call contentious cases, and that's a case where State A brings a case against State B, usually. And in those kinds of cases, we can get jurisdiction in one of three ways. So we're the principal judicial organ, but we only have jurisdiction if the states consent to our jurisdiction. The three ways are: states can consent generally, and about a third of the member states of the United Nations have done that. And states can consent in respect of disputes arising under a particular treaty, or sometimes two states will come jointly and bring a case to us. What kinds of cases do we hear? We can hear cases arising under any sort of international law, and they can come from any region in the world. Just to mention a couple of our recent cases, we just recently decided a case that Australia had brought against Japan. Japan was engaged in a program of whaling in the Southern Ocean near Antarctica, and Japan's view was that this whaling was lawful because it was whaling for purposes of scientific research. Australia challenged that and said that that's not the accurate description of that whaling program, and we agreed with Australia. Japan has indicated that it will not go forward with the program in light of our decision. A mainstay for the court has been boundary disputes, especially maritime boundary disputes. Our most recent maritime boundary case was a case that Peru brought against Chile. It involved large areas of water with significant resources, living resources, and we reached a result that wasn't what either side wanted, but also wasn't, neither of them entirely won or entirely lost. They've gotten together and have announced that they've agreed on the specific coordinates for that, to implement that judgment. So that gives you a flavor of the kinds of cases we hear and the work that we do.
Okay, thank you very much for the overview, Judge Donoghue. I said that we were going to touch on the issue of diversity. So let me say that the statute of the court requires diversity in terms of legal systems, such as the distinction between common law traditions and civil law traditions. And I was wondering, Judge Shui, whether you could comment on how these different traditions manifest themselves in the work of the court.
First of all, I have to say, I'd like to say this is a great honor to be here. When we discuss about the questions we like to relate to the audience, and we think we better give a general introduction of the court, because even if we are the longest serving permanent court in The Hague, but nowadays, oftentimes, when people ask me where you're working, and we say in The Hague, oh, ICC, You are in ICC. Are you trying Charles Taylor? And that is a question. That's why Judge Donoghue gave a general introduction to the work of the court. But when I look at this audience, I realize this is really something too basic. In terms of Dr. Williams' question of diversity, this is something we would like to bring to you. This time, thanks to Dutch government, they kindly invited 3 women judges on the bench to this session to show the progress of the court in terms of gender balance and human rights development as manifested in the work of the court. We know, according to the statute of the court, that members have to be elected from main forms of civilization and legal system. And on the bench, oftentimes you have judges from different countries, different regions, and also different background, professional background as well as legal background. And when we work together on one particular case, even if we are presented with the same facts, evidence, and legal arguments, of course, naturally, we would have different views on the case. And this is so natural. Even if from the same legal system, people would have different views, just like in national court. But importance for world court is oftentimes you can't neglect one obvious fact, that because we are from different cultural background, from different legal background, and also professional background, we may have different views. And this can be observed from our judgments as well as opinions, declaration, dissent, or separate attached to the judgment. And of course, we all look at case from legal perspective. But also you can, between the lines, see why we have that kind of different legal reasoning. So this is something I hope our international lawyers, when you read the judgments of the court, you can appreciate that diversity. And this is very, very important for the world court. I think I should stop here and let our colleagues to continue.
Well, thank you. Well, I was just going to say that Judge Sebutinde, you come from a different legal tradition from Judge Shui. Would you like to comment on how coming from a different legal tradition manifests itself in the...
Yes, first of all, I'd like to endorse the comments of my 2 colleagues, thanking the audience for being here and for the honor and opportunity that we've been given to speak on behalf of the court. The question on the table is how these differences play out in our work. For me, I've seen one area perhaps is in the area of evidence being received. In the common law system where I was brought up and trained, we are very adversarial. The civil law is very inquisitorial. And so notions of not leading a witness, notions of cross-examination of a witness, to the common law lawyer come a second nature. But there are notions that are not very easily understood by the civil law lawyer. There are other differences as well. And oftentimes, you wonder how we actually get along. But I think it's a very beautifully designed system where even the diversity in terms of profession, where you have former people from the academia, former diplomats, looking at a case from various angles, various facets, former judges. The sum total, or the outcome of the judgment ultimately, is that this is a judgment that has been examined from different facets. When you look at a case, of course all cases have a deeply political element. And you can't say that because you're judges, you're going to completely ignore the political sensitivities of the parties. But that's where the diplomatic colleagues come in, and really they're quite open and sensitive to this. The academia people will come in and perhaps their reasoning goes deeper than otherwise would be. But all these beautifully come together to create an institution that is wholesome and in which, even though we're different, we have this unity amongst us.
Good.
Can I add one thing?
Sure.
I know international lawyers attach a lot of importance to gender balance, and I'm sure people are very happy to see 3 women judges on the bench. But I can tell you, oftentimes when we discuss about cases, 3 of us, one on one extreme, the other on the other extreme, the third one is in the middle. So gender doesn't make that much difference.
Yes.
But when we come to something concerning gender, for instance, whether we still keep the French phrase, Madame le juge, we would immediately agree this, we better say Madame la juge now. So that's the difference you can tell.
Well, that's an interesting point. Gender is the obvious, another obvious aspect of diversity. Before your arrival on the court, there was only one regular female judge, Dame Rosalind Higgins. And I wonder whether the presence of 3 serving female judges has changed the dynamic on the bench at all. Judge Shui says there's no essential difference in terms of judgments, but with the exception which she mentioned. But I wonder whether Judge Donoghue and Judge Sebutinde, whether you agree or you have a different view. For example, does it provide a different perspective in any way at all on peaceful settlement of international disputes and how you reach those decisions? Judge Donoghue?
Well, of course, we can't really speak to what the dynamic was before we got to the court, because we weren't there. But the thing that has really impressed me since joining the court is the question I get most often about the way judges approach issues. The presumption tends to be that nationality must be the dominant aspect of a judge. And my own experience has been that, and I sometimes say that judges aren't paper dolls, we're not one-dimensional. We all are the product of many experiences. Of course our nationality influences the way we think. That's true for everybody in this room. We don't represent our governments, and we shouldn't represent the governments that advanced us as candidates. But so there are just these many different ways that the court varies from one judge to the next. And you can see, at least in our current composition, you can see on one issue several judges clustering together, very passionately believing something. And on the next case or the next issue might be a very different grouping. So we don't have, one sees always in the United States a literature about the justices of our Supreme Court that sort of categorizes them into 2 groups. That wouldn't work well at all for our court, at least now. Certainly one reads about earlier periods in our court where the situation was not so comfortable and where there was more of a divisive atmosphere. We don't always agree. And our job is to disagree publicly, too. I mean, that's different from any other institutions. But I'm lucky that we do it, at least for the time being, collegially. That can change. Our terms are 9 years. So the court turns over rather quickly, actually. And so the composition can change and the atmosphere will change with it.
Could I say something? When we are looking at some of these institutions and aspects of gender and so on, there's the tendency to ask the rhetorical question, is it necessary to have women judges on this court? What difference are they going to make? I think we're asking the wrong question. The thing is it right for women to participate in an institution, a UN institution, that is promoting peace, world peace? And then you find that the answer is resoundingly yes, of course, why not? And for me, I have in mind Resolution 1325, which mandates member states to ensure that women participate on an equal basis with men in the promotion of world peace. The ICJ is the ultimate world court engaged in this. And even if our presence as women did not change anything, which I'm not saying it didn't, but even if it didn't change anything, the fact that we are participating equally with men makes it all right and makes it legitimate. But on a personal note, you asked, are we making a difference? And Joan is quite right. We weren't there before, we don't know. But one judge who shall go nameless did confide in me recently and said to me, after one very heated debate, and I must tell you that the aspect I enjoy most in the court is the deliberations behind closed doors, because there's no pretensions, the gloves are off, the language is not refined, it's not diplomatic, and everybody is, what you see is what you get. So after one such morning of a heated debate, I walked up to this judge and expressed my sympathies at the biffing that he'd got during the debate. And he said to me, but you know what? The presence of you ladies has made a big difference, he said. Julia, if you had been here 3-4 years ago, it would have been even worse. But since you people came, we've tempered our language. We are more focused on the issues rather than on each other. So, yes, I think probably that is one good aspect that the women judges have brought to the court.
Okay. On that note, we do want to sound, arrogant and make our male colleagues very unhappy about it. But I want to add one thing about nationality. I think Judge Donoghue rightly pointed out. We are not representing the government of the country where we're from. But there is one element, I would say. 15 judges are elected from 5 regional groups. Does it make sense? I would say yes. For instance, when we have a case from Asia region, as a member from the region, I found I would be more sensitive to the factual background of the case. I would be more sensitive about impact of the decision, not only on the two parties, especially when the case involves armed conflict. So I would pay more attention to judges who are from the region where the case was brought up. And for that particular element, I think when you talk about nationality of the judges, I do see one element of relevance there. I think that's quite important. For me, as far as I'm concerned, if the case from Africa, I would really pay even double attention to the views of judges from that region. And this is something I think I observed in the deliberation of the court, that many judges do the same.
Well, you've touched on gender, and you've touched on nationality, and I wonder whether perhaps you could reflect a little bit on the different career paths, because we have on the stage judges who had served as foreign ministry lawyers, and we're having the case of Judge Sebutinde, a former High Court judge. Judge Donoghue, would you reflect on the key similarities and key differences between your role as a foreign ministry lawyer and now your role as a judge on the ICJ?
Sure. The obvious similarity is that we're applying public international law. I often say, and I don't have to worry about the details of U.S. law in this job, and I'm not complaining about that. And the other thing that's similar is in neither job does one control one's inbox. We don't control the kinds of cases we'll get in the ICJ, and as a senior foreign ministry lawyer, you have to also be prepared to receive questions on every aspect of international law. So it is a job like senior foreign ministry jobs where being a true generalist in international law is valuable and important, and someone who's highly specialized, I think, would have a greater challenges, I think, settling in our court. Some of the differences are, I think that on a court, one paints on a smaller canvas and with a more limited palette. And what I mean by that is if you have questions that are presented as a foreign ministry lawyer, first of all, the question is often presented before there is a clear and defined legal dispute. And the job of the lawyer is to try to diffuse that dispute and reconcile it and prevent it from erupting. And that if they're successful, the case doesn't end up with us or in some other form of dispute resolution. We don't have that role. And we can only consider legal disputes. So if a legal dispute, as is generally the case, is kind of nested within a broader dispute, the broader dispute, the other aspects of it, need to be worked out by other parts of the international legal system, by other actors. And they can make use of our judgment or orders as part of that. But we don't kind of control any of that. So we have a different role, a more limited role. There is still space for many decisions and choices that we have to make, how broadly and how narrowly to write on legal issues. For example, we face that in every issue in every case. But it is a narrower job, and on specific cases we are looking back to settle a dispute. But at the same time, because inevitably a case calls on us to refine and to elaborate the content of international law to some degree or another, we are also looking forward because we know that although what we say isn't legally binding on states that are not parties, we know that the jurisprudence will get great attention, and we consider the implications of that with great care.
Okay. And Judge Sebutinde, coming from the background as a national judge in Uganda, what are the key similarities, differences between that role and being on the ICJ?
Maybe I also should mention a little bit about my life before becoming a judge, where I was a government advisor as well, but in the role of more of legislation and treaties. I was, in my former life, a legal drafter, and I think that comes in very handy for me in the ICJ when we are trying to interpret and apply treaties. But as a judge in the High Court of Uganda, of course, the main difference was or is that one would sit alone as a single judge, applying domestic law purely, and whatever mistakes you made, well, you said there is a court of appeal exists, they'll deal with that. Here, we are a court of first and final instance, but also the fact that you don't sit alone. There are 14 other colleagues. You can always say, my tentative view is thus and thus, but I am open to persuasion this way or that way. And at the end of the day, you comfort yourself that way. In the Special Court for Sierra Leone, which is the first court I was sitting on with a panel, there, I think transitioning from working alone to transitioning to working with a team was, I must confess, a little new for me. and to learn to listen to your colleagues, to learn to amicably disagree and to articulate your disagreement in a separate opinion, I think is one of the greatest lessons that I learned and that I've carried with me into the ICJ.
Well, let me turn now to some contemporary and current political issues, if you will. I mean, in recent weeks and months, newspapers are filled with stories about Syria and about Crimea. And if you look at the international law blogs, you have debates on the legal aspects of both issues. This gives rise to two questions. First, we sit here at a meeting with a theme of which is the effectiveness of international law. And there are voices that assert that Syria and Crimea illustrate that international law is not effective in shaping state behavior, especially when the stakes are high and when views within the international community are sharply divided. Are they right? And more specifically, the ICJ is not playing any role in addressing the disparate legal views on either matter. Could it do so? Judge Donoghue?
I'm glad we have a chance to talk about that. The meeting is about effectiveness of international law, so we should be thinking hard about difficult cases. So if you look at the situation of the Crimea, for example, you see the assertions by the Russians and by those who are critical of the Russians very largely framed in terms of legal issues. That we're a court of general jurisdiction, and we have scope to apply all aspects of international law. So in principle, there's nothing that precludes us from exercising jurisdiction over this kind of dispute. But, as I said earlier, there has to be a basis for jurisdiction. So now, leaving aside the specific, which I don't want to comment on, but just speaking more generally from my experience in a foreign ministry, when a foreign ministry team is looking at a problem, concerned about an issue, trying to figure out paths forward, typically what one does is generate a list of options, and one would expect that those who are thinking about how to advance the interest of a particular state in trying to achieve its objectives would look at, are there mechanisms of third-party dispute resolution that might be available? And that would cause them to look at whether there is a basis for our court to exercise jurisdiction in a particular matter. Maybe they'd conclude, surely there is, surely there isn't. It's a gray area, and they would have to make their own calculations. There are many reasons to pick our court, and there are many reasons to pick another court. For example, our proceedings are public, and generally arbitral proceedings are not. Sometimes parties like the fact that they can make their statements publicly in our court. And by the way, for those of you who are students of international law, our hearings are webcast, and they're also available on the UN television website. You can find the link on our website. But if somebody wants to take a peek at what our hearings look like at some time, you don't have to come to the Hague, although you're welcome to do so. In principle, these kinds of hot conflicts can come to the court, and there has been some precedent for that, although not a lot. And of course, we also can serve a role in resolving disputes that have the potential to become even hotter, but haven't gotten that hot yet. And I think that one of the reasons why I think that our boundary dispute function is so important is because there are so many hot conflicts that arise over disputed territories. If we can help parties to settle those in a way that sticks, then I think we can make a real contribution in that way as well.
Okay. Judge Joan, do you want to comment on this?
I think that we have to clarify one point first. When we talk about the effectiveness of international law, it doesn't mean everything has come to the court to show the effectiveness of the court of the international law. With these hot issues, international community now has a lot of debate on the international legal aspects. That shows international law works. People are thinking in legal terms. And when we talk about international law, it's not only the court, ICJ, that is the only forum. At the legal advisor's office, at the university, law schools, people are talking, considering about the problem. Now, within UN system, as the general international organization, especially Security Council, in charge of maintenance of international peace and security, is the first, foremost forum to consider this issue. If the Security Council or the General Assembly decides that it's time that they should submit such issue to the ICJ for advisory opinion, fine. That's the decision of the states. So for the court, it has its jurisdictional limitations. It has to bound by statute to exercise its jurisdiction, either contentious or advisory. But I don't think when hot cases come up, it's always right to think immediately go to The Hague. Because we have to be very careful. When we talk about the law, law is always a two-edged sword. And I read Putin's statement carefully. I don't think he's talking about the case of the court or Kosovo. It's really the question whether you apply the rule equally, not a double standard. This is the challenge. And we also have to think, what would be the best solution to solve the current problem? We as international lawyers, we certainly like to sell our trade, but it doesn't mean the final or effective solution always lies in our own hands. So today we talk about a multidisciplinary approach. In international affairs, this is even more important. You cannot put a case in an isolated context. You always have to put it in the international relations, the general context, to consider what would be the proper solution. Now, what would be the goal? Should we strive the beauty of the law, or should we strive for the peaceful settlement of international disputes? And this is something that international lawyers have to keep in mind all the time. What is the ultimate goal for peaceful settlement international disputes for international laws? In other words, what is the mission of ours? So in short, I think when we talk about these issues, we should give an international law perspective. It's the people here. It's not only three of us. Thank you.
Judge Sebutinde, Judge Shui said earlier, in a humorous way, that there's a lot of confusion between, if I might say it, the venerable ICJ and the newcomer, the ICC. So let me add to the cardinal sin and ask about the ICC and say, how has the advent of the ICC affected the jurisprudence of the ICJ, if at all? Does the focus of the ICC on accountability have an effect on peaceful settlement of disputes, or does the growing controversy over the ICC's role, for example, in Africa, have an impact on the willingness of states to submit to the jurisdiction of international courts?
Okay, I think I'll comment on that as that last aspect that you mentioned. The advent of the ICC has been fraught with, how shall I even put it, debatable views, especially from the African continent. The African countries were very enthusiastic, In fact, it was the largest bloc, global bloc, to accede to the Rome Statute. Enthusiastically, they were the first nations to refer situations to the ICC. And so they started off very well until I think certain indictees started appearing before the court. And then things began happening. The court the states parties became disenchanted with the court. And not only that, but anything coming from The Hague has tended to be disenchanting to the member states, the African member states. And I think it's a challenge for the ICJ to reach out and explain what it does. I think in the beginning, Judge Shwe did say, and I find the same experience everywhere I go, I'm referred to as the ICC judge. And for me, it's even worse because my former work involved trials similar to what the ICC is doing. But I've never been an ICC judge. And when you say that, the people, their eyes are wide open, like, say, what? So I think the ICJ has a challenge to explain, as we are doing now, what it is that the court does. That is not to say that the perspective that castigates the ICC is a correct one. I disagree with that perspective particularly. But of course the ICC have their own challenges that they must work through. The prosecutor has her own challenges she must work through. And but I'm happy also to say that I've seen in the ICJ that member states from Africa, and I think I say this without any bias whatsoever, whenever states from Africa have agreed to bring cases before the ICJ, they receive the judgments of the court very well, they cooperate well with the court, and when it comes to implementation, we never get any issues with them. So far, we might even get a very nice and kind letter signed by the agents of both countries a few weeks after the judgment to say, we thought you would like to know, we have started demarcating the boundary according to the judgment that you gave. That is very encouraging to the court to see that even though sometimes the judgment is not pleasing to either one or the other, but the countries do accept. And for me, that there's hope, at least from the African continent. Again, coming personally from an area where we've experienced conflict. This is the Great Lakes region. Just unceasing conflict throughout my lifetime. We've known nothing but war and conflict, and we're always on the brink of war with one or the other neighbors. I think that the ICJ has a big role to play, that could play, if the African states care to refer cases like their disputes there for peaceful resolution, rather than resorting to armed conflict, for instance. It certainly is a concern to me personally, because I've seen what war does to women and to children. They suffer most when the war breaks out. It takes back countries economically, and nothing good comes out of armed conflict. So I would really encourage African states. And I think for me, I did dedicate myself when I was appointed to the court to say, I'll take every opportunity. I may be one little woman, but they're going to listen to me whenever I speak concerning conflict resolution in Africa and the avenue of the International Court of Justice as a possible way of settling peacefully the disputes.
Good. Well, I'd now like to give an opportunity for the audience to ask questions. As I said, I'll take them in groups of 3. I see there are 2 microphones at both sides of the hall. It might be easier for you to, if you need to ask a question, perhaps to go to the mic. Yes, is it Joan?
Hello, my name is Mark Wojcik. I'm a professor at the John Marshall Law School in Chicago. It seems to me that countries are going to the court more often now and also seeking preliminary measures. And in the recent decision with East Timor and Australia, one paragraph of the decision said that the court doesn't always have to give the preliminary measures that the parties are asking for, and you might come up with something else instead. I'm just wondering what might influence your decisions on coming up with preliminary measures other than those that the parties are seeking.
Okay.
Thank you. I'm Alain Pellet, Université Paris-Ouest Nanterre La Défense. I have two brief questions. First, seen from non-common law countries, and not only France, the court is seen more and more as being dominated by the common law way of thinking. And I must say that as a practitioner, you endure me quite often. I am not far from sharing this concern, in particular, and Judge Sebutinde hinted to that, in particular concerning the rules of evidence. I think that now you are more and more unbalanced in your approach of evidence, and that you have clearly Anglo-Saxon or a common law approach of evidence. I will be happy to know what are your reactions on this feeling, which again I think is very honestly quite widely shared in probably non-common law countries at least. Now my second question will be very brief, but maybe you will think it is self-serving. Just the question is, what is the role of oral pleadings in the outcome of cases?
Okay, thank you. And then the third.
Yes, thank you very much. My name is Cornelia Weiss, and I'd like to find out what your plans are to actually make your website more user-friendly for research. Thank you.
Okay.
This is important.
All right. So, who would like to go first? Judge Donoghue? All right. Why don't you go first?
I'd like to respond to Professor Pellet's questions, but I would also, I can't answer, none of us I think can answer the question about our website without a better identification of what its flaws are seen to be, which obviously would be interested in taking back for consideration. So if I would just suggest that the speaker come back up and tell us more about what are seen as the problems. So to Professor Pellet, so the suggestion is that the small minority of common law judges on the court, and we are 5 out of 15 now, but if you look at the way the court is, the traditions associated with selection of the judges, it's hard to think of how there could be more than 6. And maybe it could drop down to 3 or 4. Well, generally, we're going to be about a third. So you're suggesting that we are so muscular that we're able to squeeze out those lazy civil law judges, those shy, retiring judges from the civil law countries, and we just bowl over them. And that can't be right. That can't be right. Now, so another hypothesis would be, well, the common law system is clearly better, and even though there might be some people, there might be some people in the room who think that. I'm not going to advance that. But what I would say is a significant amount of what we do is party-driven. And let's use a case that you know, a recent case, Australia-Japan. Australia is a common law country. It came to the court and put forward expert witnesses. It said, we want to come to the hearing with expert witnesses. Civil law countries are not enthusiastic about party-appointed witnesses. Our court provides for the appointment by the court of experts. In that case, the way the case played out was that Australia put the witnesses on the stand. They were cross-examined and judges asked questions. And then Japan put an expert on the stand and the same thing happened. Now, if the case had been brought by a civil law country against a civil law country, we might not have seen the same thing. So there's an example, I think, of party-driven. The role of oral proceedings. Well, many people are surprised to know that it is very rare that ICJ judges ask questions from the bench. We've started more recently to ask questions in which we ask in the first round of oral proceedings for the party to respond to our question in the second round, and I find that very useful, and I imagine that it's helpful to the states as well because they feel like they have a chance to answer questions that are bothering a judge, that we don't just go away and feel unhappy that we never got an answer. Do our oral proceedings look like they come from the common law tradition or the civil law tradition? I have to say, certainly common law judges are very surprised to hear that we sit mostly silent. So I find it a mix. I will say, however, that former president of the court, Manfred Lachs, once said we had the best of both worlds. And I think there's a significant risk that we can at times have the worst of both worlds, because since we don't have well-articulated rules on certain of these issues, we sort them out often on a case-by-case basis. And when you pick and choose from one system and another, you lose the idea that there exists a coherent system that fits together a piece. And so we have to be careful as we operate in this space where we are drawing from two systems, that we don't sort of pick and choose in a way that is less functional than either system on its own might be. I'll stop there. There's more to say, but I'll stop there.
Should I let the two common law lawyers?
Let's
gang up on you.
No, we don't want them to gang up against you. So why don't you?
I belong to
The middle.
neither, so I may say something just as my personal observation. I'm not so sure court is common law dominant. I found court actually is more influenced by civil law, to be frank. You like it or not, or agreed or not, I think that's by tradition. In terms of members, it's really not up to the court, it's up to the states to elect. Of course, members matter. When the composition change, you may see a little bit nuanced change in practice. I have to say, oftentimes lawyers, not particularly international lawyers, may tend to judge court's work from domestic court perspective, often think in domestic context. Court, as I see it, is much more complicated. For instance, in oral proceedings, even if the members do not ask questions or do raise questions, you really have to be careful. Because when you raise questions, you're really addressing to the state parties. Even they have the counsel, the agent, you have to imagine when you raise questions not purely factual, or could be very nuanced factual questions. Agent and counsels are very careful, very cautious in answering the question, and sometimes could be very decisive. So as you are the most experienced counsel before the court, I won't dwell on that anymore. I just want to say, as a member, member from, generally speaking, common law legal system, I have been very cautious in raising questions. I found first foremost important for the members to listen to the oral proceedings. This is the question raised by Professor Alain. I think we haven't addressed the question about provisional measures. It's according to the statute, as well as according to the established practice of the court. Certainly, the court has the discretion to render provisional measures in light of the facts and the necessity of the case to render provisional measures. So it's not something the court only gave render provisional measures as requested by parties. And this is the general practice.
If I may add on the issue of the question raised, what influences the court's decision on provisional measures, and why is it that sometimes the court will grant different measures than have been asked? Well, one of the things that influences whether the court will or will not grant provisional measures is whether they're necessary. They're not necessary just because a party says they want measures. And very often it happens that the measures requested, actually, the effect, if granted, will be to prejudge the merits. So that is one example where a measure requested actually is the same as in the final prayer of the merits. Then obviously the party is trying to prejudge the issue, and the court will not grant such a measure. Another instance where the court will not grant a measure is where the irreparable prejudice has not been illustrated or demonstrated by the applicant. Or where actually the applicant has demonstrated irreparable damage but has not been able to articulate the kind of measure that the court thinks will prevent the irreparable prejudice. So there again, the court will substitute its own measure with the aim of maintaining the status quo and preventing the irreparable prejudice until the merits case. I think that's all I would say. We would really be interested to hear the lady in the balcony, I think, who said, and of course you had a resounding applause about the website of the court being not efficient, not friendly. You're really asking people who don't use the website, and maybe it serves us right that we're sitting here and we're totally undressed for this. Yeah. But we would appreciate if you would be a bit more specific, maybe in the subsequent comments, to tell us what it is that is unfriendly about the website.
But I have to say, I'm a little bit surprised to hear that remark. To my knowledge, our registry has been working quite hard to improve the website and try to make to assure high quality of our website. And so in terms of research needs, you really have to let us know. Maybe there's a limit to our competence.
Well, this is an area where this young and vibrant think and do tank called the Hague Institute for Global Justice in The Hague might play a role. So we're happy to play a facilitation role. We have, if you go to our website, you can send the questions and your analysis, and I'll be very happy to play this facilitation role when we get back to The Hague and pass it to the registrar, okay? Let's take the second round of questions, and I see 3 members of the audience at the microphone. Just your name and again your institutional affiliation.
I'm Richard Allen and I'm from Baker & McKenzie in London. You mentioned briefly the choice that states have between arbitration, the ICJ and various other fora. And you've also mentioned how the court has adapted some of its procedures in the taking of evidence, for example, to suit the party's will. I'd be interested in your respective views on how far the court should go in that respect. For instance, the debate about the Chamber's procedure and whether parties should be able to choose particular judges to form part of that chamber, and whether any motivation for the ICJ to do so is purely on the basis of competition with other forums, or whether there is a general reason why the court should adapt to suit the will of the parties, perhaps on the basis of consent upon which the whole court's jurisdiction lies.
Thank you.
My name is Ved Nanda I teach at the University of Denver Law School. Some of us in the academia may be unwarranted, but feel that there are so many international tribunals now, and with their interpretations, that there might be some confusion about the jurisprudence that is being developed all over. Would you kindly comment on it? Obviously, there might be some consultations, there might be some avenues open where the possibility of judges getting together or finding a way to see that there is some kind of cohesion and common way of interpreting international law doctrines.
Thank you.
My name is Christina Cerna. I teach at Georgetown University Law Center, but more importantly, in this context, I'm chair of the ILA, International Human Rights Law Committee. I have a question and a recommendation. The question is, would you comment on the impact of international human rights law on the ICJ? And if you think that the background of Dame Higgins and Judge Bergenthal, for example, having been on the UN Human Rights Committee, made the ICJ more sensitive to concerns of the individual and not just states. And my recommendation is on the basis of what Judge Sebutinde said about the deliberations. One thing I've learned from my ILA colleagues is that in the Brazilian Supreme Court, the deliberations of the Brazilian Supreme Court are public and televised. I would recommend that maybe the deliberations of the ICJ should be televised.
Okay.
Terrible.
Good. Judge Shui, do you want to?
Let me start from the last one. It's most amusing one, I think. When I first came to the court, our university trainees and our clerks had a meeting with each one of the judges. One of the first questions or requests they raised to me, addressed to me, was whether they could participate in the deliberations of cases by members. And I have to say, their reasoning is quite strong. And as a new member, my initial reaction was certainly not. Why? Because in the deliberation, that's the place and that's the time where judges must feel under no pressure can expressly view their opinion, position. And that's the place, time, the judges can freely exchange their views and debate. And this part should be kept confidential. Yesterday, we were at the Supreme Court in the United States. We are very happy and honored to meet two judges of the Supreme Court. And we were told in so many years, in so many cases, the internal deliberations on the Supreme Court has never been leaked. And you may wonder, of course, this is a very impressive record, and also a high standard of professionalism. But you have to see the merits in it. This is not a Congress. It's not a debate about among the people's representative. Whether your representative really argue your case in the Congress or in the Parliament. This is a judicial body where you have to consider the legal as well as policy considerations. it has to be confidential if you want to assure independence of the member. This is my first response. I thank you for your recommendation, but I feel sorry we can't accept it. For human rights, of course, Judge Higgins, Judge Bergendahl, they are really very high figure in the field of human rights. But I have to say, the court as a whole has been, ever since at least, as I observe it as a member on the bench, has been very conscious about human rights promotion. If you look at our recent cases, we have dealt with quite a number of cases relating to human rights. In the Diallo case, and you see from traditional diplomatic protection, the court even look at human rights aspects. That was the first case. And in the following other case, I think the court has been quite active in this field. In our deliberations, I can see that easily. And now come to the second question about the fragmentation. The issue has been in the corridor, in the discussions, in the writing, the scholarly writings, being there all the time. And actually, LC had dealt with the case by setting up a special study group on the question of fragmentation. And intentionally, LC, the Law Commission, did not touch upon institutional relationship between different judicial organs. And certainly this is the aspect lawyers often concerned about, whether there would be fragmentation, whether we can come up with coherent interpretation of law just as constitutional court. Personally, I have to say, as a practitioner, I don't feel it's the right approach, because the basic legal structure and framework of international is different from domestic. At the international level, you don't have this constitutional framework in the first place. And if you look at those alleged fragmentation, I don't see they really create real problem there. And of course, we have one particular Tajik case as effective control, overall control. But I think the court, ICJ, has dealt with the case quite nicely, while giving due regard to ICJ's jurisdiction and interpretation. And should I address all of them, or maybe I should give more time to other colleagues? I've been talking too much. Yeah.
Yes. Judge Sebutinde, would you like to?
I'll say something on the alleged proliferation of courts, because I don't think it's a reality. These institutions, I suppose you're referring to the ad hoc tribunals, they each have a different mandate. They're dealing with a mandate, a specific mandate, that could not be brought under the ICC for obvious reasons. And although they all deal with similar conventions, the Geneva Conventions, and atrocity crimes and so on, and the way that these courts interpret certain of these provisions, I think it has to be seen in that context, that they are dealing with specific mandates, and none is binding on the other. And I think with the establishment of the permanent court, the ICC, we are going to be in for a very big surprise when the cases start coming out, the judgments start coming out, because the ICC does not consider itself bound by the decisions, for instance, of the ICTR or the ICTY appeals chambers. They are trying to develop their own jurisprudence, For obvious reasons. They're sitting with their own statute that they have to administer and develop jurisprudence from that way. But really, as a person from the academia, I would have thought that the more the variety, the greater the variety, the merrier the meal, I would have thought. But I'm surprised that you're complaining about the different decisions and the interpretations that are coming out of these courts. The courts are here to stay. Some have come and gone. They've left the jurisprudence out there. I think it's a very rich source of jurisprudence, none of which is binding particularly. But I think it's a very good source for upcoming academicians to debate and to identify similarities and differences and to draw parallels. The impact of international human rights law on the ICJ. In my short life so far with the ICJ, and I'm really grateful that I'm seeing all these different cases coming up, each case is different. For me, it's particularly interesting when a case comes up that involves human rights issues or that involves atrocity crimes, that involves genocide or torture, and that involves maybe aspects that have been dealt with before by other international courts from a different perspective. This morning we were having a similar debate where, for instance, the ICTY, looking at the conflict in the former Yugoslavia, dealt with certain aspects of that conflict and dealt with certain individuals apportioning individual criminal responsibility. Now, the same situations have found themselves before our court, the ICJ, in the Bosnia-Serbia case and others, where the court did look at the judicial findings of the ICTY, appeals chamber and trial chambers, where those were relevant, and treated them as persuasive. They were not binding, but they were persuasive, and the court did not think that it was in the interests of judicial economy to revisit and call the evidence afresh. So those findings of fact that had been made by international judges of the ICTY became very valuable findings in helping the court deal with state responsibility, not individual criminal responsibility, but state responsibility under the Genocide Convention. And there is, I think, one of the impacts of international human rights law, humanitarian law on the ICJ. And so again, to go back to the gentleman who was complaining about a proliferation of courts, I think it's interesting to see how these courts, complement each other and how the jurisprudence of one is treated by another. I mean, this is a wealth of experience for the academicians coming up. That's my own personal view.
Judge Donoghue, do you want to reflect on it, or should I take the final round of questions?
Let me just make two comments. First, we didn't hear any reactions on the question of chambers. So let me just say on chambers, we can't impose them on the parties. The parties have to request them. They rarely do. And my hypothesis has been, although those who have represented states more frequently than I have might offer their own perspective, my hypothesis has been that frequently the assessment of the state is that what it is looking for is the seal of approval from the World Court, and there might be a perception that a smaller chamber doesn't deliver the same punch. And that could be, for example, looking at how they will move forward to implement a judgment, favorable or unfavorable, after a decision. On the question of the multiple courts, it never bothered me when it became a topic of great interest, I think because I think of the international legal system as inherently decentralized anyway. When we face a question that is common to issues that have been looked at by another court, and that is exactly what we're doing now in the Croatia-Serbia case, because in that case we have competing contentions by the two parties about how we should take stock of ICTY and Rwanda jurisprudence. When we have those situations, we have to do it with great delicacy. There's no doubt about that. The one area that I think is the trickiest, and it's something scholars have written on, but doesn't present itself in real life very often, and maybe it will, is what you might think of as a double jeopardy problem. It is problematic, at least hypothetically, for State A to bring the same dispute to multiple jurisdictions that happen to have jurisdiction over the same dispute. That's not the same as related disputes, and one is a question about individual accountability, and one is a question about state responsibility, for example. But the same dispute, same legal question before two bodies feels unfair, and it's the kind of, I think, concrete problem that needs to be addressed, and that the courts, because we're all created separately, won't have immediately, obviously, ways to sort through it. We can't kind of pick up the phone and say, hey, let's just flip a coin on this one or something like that. I'll stop there.
Okay, thank you. Let me take the final round of 3 questions. The lady on that side.
Thank you very much. Dr. Marie-Claire Cordonnier-Seger. I'm from the Lauterbach Center for International Law at Cambridge University, and I'm also senior legal expert on sustainable development. With the
Could you speak up a little louder?
I'm going to move the mic so that it's too short, and I'm not that tall. Better? Yeah?
Yes.
Okay. Hi. I'm Marie-Claire Cordonnier-Seger. I'm from the Lauterbach Center in International Law from Cambridge University, and I'm also a senior legal expert on sustainable development with the International Development Law Organization. We just launched our office in The Hague last week. I actually have a question for you. First, in terms of the question about research and the website, our committee here in the ILA over the last 10 years has been working on comparisons of different courts and tribunals and how they address certain ILA principles on sustainable development that were launched with our New Delhi Declaration. And we've been spending a fair bit of time for a new book on sustainable development in international courts and tribunals, going through and using the websites of the various courts. I would have to say, you're not among the worst. Your registrar's efforts have been noted, and we're using them. So if you are going to have a dialogue about improving it, we're happy to help. But I think you've already done some progress. Thank you for that. My question following on this is that in our new committee, which was launched here in Washington, we actually reviewed your case on whaling yesterday, and we're having the impression with the scoping we're doing and with the literature that we're reviewing that there are more cases on sustainable use of natural resources and on the environment coming forward in the court now. Why do you think that is? And is this also your impression indeed? Thank you.
Hi. My name is Lauri Melksoo, and I'm an international law professor at the University of Tartu in Estonia. I was wondering if you read the book by the late Antonio Cassese, Realizing Utopia, the chapter on ICJ. The book is about how international law and international institutions could be, not how they are. And he actually, quite topically in today's panel's context, he compares the ICJ with a grand old lady and basically comes to the conclusion that it is a little bit old-fashioned in some ways, or constituted in an old-fashioned way. And I was just wondering whether you think that the ICJ would need reform in some way as well, as many say that the UN does. Thank you.
Thank you.
Thank you. Hans Corell, former legal counsel of the United Nations. I now have a piece of information that I share with you in my capacity as a member of the advisory board of the Brandeis Institute for International Judges. This institute was founded in 2004, and the first chairman of the board was Ted Sorensen, and he has now been succeeded by Richard Goldstone, and Tom Bergenthal is also on that board. They offer an opportunity for judges from all the different international courts to get together at an institute and discuss with each other common ideas, share views and so forth. And I must say I've been present in 3 of the institutes, and it's been fascinating to participate in those discussions and particularly listen to the judges. May I suggest that you look at the latest report from the Institute held last summer in the cooperation between the Institute and the University of Lund and the Raoul Wallenberg Institute in Lund in Sweden. The ICJ was represented there by 2 judges, including Hisashi Owada, former president of the court, and the latest report has his foreword and his very appreciative comments about it. So I suggest that you all Google Brandeis Institute for International Judges, and then you can look at the reports. And I hope that many more judges from the international courts will have an opportunity to participate in these institutes. Thank you.
Thank you. So, Judge Donoghue?
I'll take on the question about the old lady, the ICJ. So, you know, I'm American, so we don't have very long traditions, and we change things rapidly, and I think we have a relaxed attitude towards that. So my natural instinct, if I see something that works, is to say great, and if I see something that looks like it could be improved, to say improve it. Some others, maybe culturally, maybe personally, like to stick with what's familiar, and that's I think not a huge surprise. We have made some changes, though. I think we have made some changes. The court used never to cite the jurisprudence of other courts, and we were talking about human rights cases, for example. Well, we recently were asked to set compensation for a breach of international law that was a violation of human rights obligations. We don't get that kind of case very often, and we sorted through the best way to do that, drawing significantly on jurisprudence of regional courts that do that regularly. We used to deliver our orders in one long sentence. I think Alain may have left, but he would have probably said that was very good because it was a French tradition. And we decided to change it so that we now use a normal, okay, I'm American, so we're a narrative style, not one 50-page sentence, but a narrative style for our orders and for our judgments. I think, I often say that the younger judges and Judge Keith, who is one of our judges who's not terribly young but quite modern-oriented, we are often looking at ways that we can change and improve, and of course we can get ideas from looking at other courts. So I think change may be slower than some people would wish it would be. We can't change the statute. We can't change the statute, and I frankly don't see a prospect that the statute will be changed anytime soon, because to open up our statute and in associated ways potentially open up the UN Charter, I think it would surprise me if there is an appetite to wade into that. But if it does happen, it will be quite interesting.
Judge Sebutinde?
Yeah, I haven't read Judge Kasese's book, and I'm not sure when it was published, but I think it was not fair for the late Judge Kasese to have described the 15 gentlemen that have dominated this court for 6 decades as an old woman is just, incredible. And then to address that to us is really
older man,
funny.
Not the older lady, older man.
I don't know, but I think that should probably be put to our brothers that we left in The Hague. They might have comments on that. But I think Judge Donoghue is absolutely right. There have been changes that are happening. I think there are good changes in the court. One thing is that the judges being appointed are coming younger and younger every year. And that obviously means that they come with fresher ideas. The ideas are not always accepted by the older colleagues, but I think by and by they're changing slowly. And I, for one, I think that the current president that we have is very good for the court. He belongs to the younger generation, and he's vibrant. The pace at which the court is moving and handling cases, keeping on top of our schedule, is to be commended. I was told that there was a time when a judge in their 9-year term would probably handle 3 cases, if they were lucky. Now, I've been in the court 2 years and I've done, I think, 6 cases so far in 2 years. Now that's commendable. That's a good change that comes and goes without being noticed. But I think the court is moving in the right direction. The judges can change the rules, and there I'd have to agree with you that perhaps there is room for reform in the rules. I, for one, have always wondered why we refer to the rules as by article. You refer to the statute by article, you refer to the rules by articles, and sometimes people don't even bother to differentiate Article 24 of what. Being a former legal drafter, I don't know why we don't call rules rules. Rule 1, Rule 2, Rule 3. Instead of Article 1, Article 2, Article 3 of the rules. I don't understand that, but I am signing up for the Rules Committee, and I hope that I will be listened to when the time comes, because it's quite logical for me to call the rules by their name. That's just one example.
Well, I think Judge Donoghue, Judge Sebutinde Bush touched on reform, but I wonder whether perhaps Judge Shui, well, you could also touch on the reform issue, but I haven't had the issue which was raised in the first question about the increasing number of cases dealing with sustainable resources coming to the court.
Well, that question is a very good one. It's a very good observation, but I have to say, what kind of cases that will be submitted to court does not depend on the court. It's really the state's choice. That tendency shows that the states have a more confidence and really more willing to submit this kind of cases to the court. And indeed, through court judgments and jurisprudence, we contribute to the development of environmental law and sustainable development. That's a good development. As to the last information by Mr. Hans Correa, and we'll certainly pass on the message to the court, and hopefully we can make the best use of this exchange. Now, last, I think I endorse what my two colleagues said about this old tradition. Either old lady or old man, doesn't matter. I want to lay stress, maybe these things often being neglected. ICJ actually continued from PCIJ. If we take a look at what PCIJ had laid down as a foundation for this permanent court, and what ICJ has developed from there is really quite amazing. And because from the very outset, PCIJ has laid down very solid foundation, both in terms of its procedural rules, institutional build-up, and the substantive law, is quite a solid foundation. Recently, the court had compiled the books introducing the court, because last year was the centennial of the Peace Palace, and I really like to take this opportunity to do a little bit of PR for the Hague and the Peace Palace. They have produced quite a good book. If you look at those books, you would appreciate the history of these two legal institutions. And of course, as a non-Western scholar, I often criticize Eurocentrism. But on that point, I have to say, this is the contribution that European countries have made to the world. And if you look at the current judgments, or the judgment delivered throughout, very solid. If you see the reasoning, the judgment is very, very good source for international legal studies, very good evidence for international law. So there's no surprise that wise scholars attach such importance to the jurisprudence of the court, to the judgment of the court, even if they were not party to the case. And why states, when they appear before the court, they give such importance to what they say. And I remember once Professor Brownlee told me, you know, for international lawyers, what would you should look at? Not only the textbooks, of course you should look at, but you really should see what the states argue, plead before the court. That's what they think what national should be. I studied here in the States. I thought I know something about the West, but once I live in Europe, I found it's quite different. One thing I learned from Europe is really you have to have high respect for history. So I may sound very conservative, but I feel it's a positive term. Thank you.
The ICJ judges. It was wonderful.
If I may echo Dr. Williams' thanks to all, but also add one very practical note. The reception and the receptions and the dinner are tonight in this building. But as all of you should have received by email because of some